More legal uncertainty for Privacy Shield ahead of crux ruling by Europe's top court. Facebook tried to block the referral, but today an influential advisor to Europe's top court has issued a legal opinion that could have major implications for the future of the EU-US Privacy Shield personal data transfer mechanism. It's a complex opinion, dealing with a fundamental clash of legal priorities around personal data in the EU and US, which does not resolve question marks hanging over the legality of Privacy Shield. The headline takeaway is that a different data transfer mechanism, which is also widely used by businesses to transfer personal data out of the EU, so-called Standard Contractual Clauses, SCCs, has been deemed legally valid by the court advisor. However, the Advocate General to the Court of Justice of the European Union, CJEU, is also at pains to emphasize the obligation of data protection authorities to step in and suspend such data transfers if they are being used to send EU citizens' data to a place where their information cannot be adequately protected. So while SCCs look safe as a data transfer mechanism, per this opinion, it's a reminder that EU data protection agencies have a duty to be on top of regulating how such tools are used. The reason the case was referred to the CJEU was a result of Ireland's Data Protection Commission not acting on a complaint to suspend Facebook's use of SCCs. So one view that flows from the opinion is the DPC should have done so, instead of spending years on an expensive legal fight. The backstory to the legal referral is long and convoluted, involving a reformulated data protection complaint filed with the Irish DPC by privacy campaigner and lawyer Max Schrems challenging Facebook's use of SCCs. His earlier legal action, in the wake of the 2013 disclosures of U.S. government mass surveillance programs by NSA whistleblower Edward Snowden, led to Privacy Shield's predecessor, Safe Harbor, being struck down by the CJEU in 2015. On the SCC's complaint, Schrems prevailed in the Irish courts, but instead of acting on his request to order Facebook to suspend its SCC data flows, Ireland's data protection watchdog took the unusual step of filing a lawsuit pertaining to the validity of the entire mechanism. Irish courts then referred a number of legal questions to the CJEU, including looping in the wider issue of the legality of Privacy Shield. It's on those questions that the AG has now opined. It's worth noting that the Advocate General's opinion is not binding on the CJEU, which will issue a ruling on the case next year. Although the court does tend to follow such opinions, so it's a strong indicator of the likely direction of travel. The opinion, by Advocate General Henrik Sorgmansgaard OA, takes the view that the use of SCCs for the transfer of personal data to a third. For more on this story, visit the news article link.